Mr. Metcalf, are you ready? Yes. Okay. The chair would lay out House Bill 2596 and recognize Representative Metcalf.
Thank you, Mr. Chairman, members. Good to be with each and every one of you this morning. Under current state law, victims of sexual or aggravated assault are granted access to a protective order under Article 7B of the Code of Criminal Procedure. However, if someone breaks into your home with the intent to commit sexual assault or aggravated assault, the victim is not entitled to a protective order. House Bill 2596 expands Article 7B of the Code of Criminal Procedure to provide protective orders to victims of home break-ins with the intent to commit sexual or aggravated assault. Protective orders are essential for safeguarding victims of burglaries, particularly in cases where the perpetrator has attempted assault, as such orders provide immediate and critical legal protection. In instances where an individual has unlawfully entered a residence with the intent to cause harm, the risk of further violence remains high, and the safety of the victim is compromised. A protective order serves as a preventative measure, legally prohibiting the alleged offender from contacting or approaching the victim, thus mitigating the potential for subsequent violent acts or intimidation. The issuance of such orders not only ensures the physical security of the victim, but also upholds their right to live free from the threat of harm, fostering an environment for safety and justice. Members, let's ensure that victims of break-ins where a perpetrator attempted sexual or aggravated assault are granted the right to obtain a protective order. Thank you, Mr. Chairman.
Okay. Any questions? Mr. Wu has a question.
Yes.
Okay.
I understand exactly what you're doing.
Good.
Why not just make it burglaries? If somebody just breaks into your house, they know where you live, and if someone it doesn't, and even again, and the more the point is, I think the way this is drafted up, you would have to there would have to be some kind of finding of proof of the sexual assault or the attempted sexual assault. I think that's kind of hard.
Okay.
And I would say, like, I'm worried that the people who would actually need to use this wouldn't be able to use it because they wouldn't be able to meet the requirements of, like, because if somebody's been arrested for it, the DAs may not want you to put out all the evidence of, hey, this is what we're going to use against them to prove out the attempted sexual assault or the burglary, and that. But I think if you just make it burglary, it's a felony. You're breaking into someone's house, and even people who were not like attempted to be sexually assaulted might still like, hey, I don't want this guy back at my house. Then they know where I live. Just throwing it out there.
I get it. I understand. I would like to defer that to one of our witnesses here today, if that's okay. And I fully understand where you're coming from, though.
Okay. Any other questions?
I'll just say that I mean, Representative Wu's point is well taken. It's very difficult to establish someone's intent after they've committed a burglary. Obviously, they're intending to do something illegal when they get there, which kind of satisfies the predicate or the elements of a burglary. An entry into a dwelling with an intent to commit some other offense, but it's very difficult to dial in on what they intended to do when they get there if they were interrupted and arrested in that purpose. So,
Okay.
I think Representative Wu's statement is well taken, that the bill may have more effect if that subsection dealing with committed the offense with intent to commit an offense listed in subdivision 1 of the subsection, if that part is stricken, I'd certainly consider that as well.
Understood. Thank you for the feedback.
Ms. Jones?
Thank you for bringing this bill. I actually agree with Rep. Wu. I've had my house broken into, and the truth is, you never have peace anymore. Especially if you don't know who did it. And the one place we should feel safe is in our homes. So, I mean, if you changed it, because I don't think that it's that just because you break into my house because you want to do something sexual to me doesn't mean that if you just break into my house, I'm still not terrified.
Understood.
Right.
Yeah.
So, and sometimes you may break in to do something and it goes really wrong and really bad, and the next thing you know, I'm dead, and then there's a capital murder. So I just don't want people at my house
Understood.
or anybody else's house.
Agreed.
Thank you.
Thank y'all for your feedback.
Mr. Money?
I'm going to belabor the point just a little bit more. No, I appreciate everything everybody said, but as I was reading through this, and I think it's a good,
Yeah, I
it's a
understand.
good bill.
I understand.
But I would think that most of those people that apply for a protective order under the subchapter, or that apply for a protective order are doing that against someone that they know and they've had prior contact with, usually a family member, someone like that. And I don't care if that person broke in to apologize. If they break in to apologize, to Ms. Jones' point, that's a terrifying thing. That turns into that. So if we've had an altercation and you've broken into my house for any reason, after that,
It's a problem.
I think we need to allow for a protective order there.
Absolutely. Thank you. Thank you, Mr. Chairman.
Any other
members.
questions? Good. Thank you, Mr.
Thank you.
Metcalf. And so Chair calls Britt Ligon. Ligon? I ought to know that, I'm sorry.
Good morning, sir. How are you? My name is Brett Ligon. I'm the District Attorney in Montgomery County. We are the county immediately north of Houston. The small city where I'm from, Montgomery, Texas, is otherwise known as the birthplace of the Texas flag. We have the Woodlands, Lake Conroe, and steer communities like Cut and Shoot, Texas. So that's where we're from. We had asked Representative Metcalf to file this bill based upon a case that had occurred within Montgomery County, but listening to Professor Jones, Wu, and Little, I believe, I'm in complete agreement. I was here to defend a narrowly tailored addendum to the protective orders, but I believe that Vice Chair Wu and Committee Member Jones have struck the nail on the head. When you burgle somebody's home, the way that the statute currently is, it's not just to commit a theft, right, which it was when you and I were in law school. It's been amended to also include assaults and to include sexual offenses as well. So these are all first-degree offenses by themselves, and so I do agree, as amended, issuing a lifetime protective order against somebody that has committed the offense of burglary to protect somebody's home, because we don't expect a victim to have to move out of their own home just to remain safe in their domicile. So I agree with the provisions, and I will quote Ms. Thompson earlier, this is a beautifully crafted piece of legislation. With y'all help, I think it got even better.
Any questions? Mr. Wood?
And I think, I don't want to beat this point to death, but again, I think to Rep. Jones's point, like, dude, if somebody broke into my house, it would make me feel a whole lot better. I know that that person might be in jail, or they might not, they might get out at some point. I would feel a whole lot better if there was just something that says, hey, by the way, even after you get out, don't go anywhere near there.
Well, and to your point, regular burglary is 2 to 20. If it's one of the aggravated offenses, it is a 5 to life. But oftentimes, if you're dealing with an offender that has a long period of life left, say it's usually a domestic violence relationship, or as you indicated earlier, these are usually burglaries where somebody knows somebody. They're the known assailant. And so the lifetime protective order would extend even beyond the period of deferred adjudication or beyond a period of incarceration. But the statute as exists does allow those people to petition the courts to remove the protective order at some time in the future. So all that is already in the statute. So I believe it does protect everyone with y'all's addendum.
Make the prove up a lot easier.
Thank you.
Anything else? Ms. Jones?
I also like that the victim doesn't have to go and try to pay for a protective order in protective order court, right? And then you don't always get a lifetime protective order.
Correct.
I know that the MOEPs actually, and that's the emergency order of emergency protection, for those of you who don't know what that means. I know you know, but this is for the listening audience. That is like 61 days or something. So when
61 days if it involves a weapon, 31 to 91 otherwise, but can be up to 91.
Right, but my point is this. I cannot tell you the number of clients I'm like, this over in 61 days, or this over in 91 days. Well, so I still don't want you at my house.
Exactly.
So, and so a lifetime protective order, I think is important because it also accounts for, if I have a lifetime protective order just by you coming into my house, if I move and you are ticked at me because I helped prosecute you, if I move somewhere else, you can't come to me either.
Correct.
And go there. So I'm glad to see that, Because as I will say before, to this day, when I go to my house, I keep my head on a swivel. For those of you who don't know what that means, because it's Ebonics, I'm looking around because my house has been broken into, right? And I just want to make sure, and when I get into my house, I lock the door and I turn on all the lights and I go check it. Before my house was broken into, that never happened. It never occurred to me that someone would invade the most personal and private space that I have.
Yes, ma'am. I understand.
Okay.
I agree and agree.
Any other questions for Mr. Ligon? Okay, appreciate you being here.
Thank you.
Is there anyone else here to testify for, against, or on House Bill 2596? There being no one, Mr. Metcalf, if you want to close?
Thank you, Mr. Chair and members. This is a pretty bill. We'll make it a beautiful bill after y'all's, after your feedback. We'll come back with a committee substitute. That's
Okay.
okay.
One thing that you might do, in fact, I'd recommend doing, is checking with a parliamentarian to see if broadening this bill might cause you some parliamentary problems. I don't think it does, but it's
We'll confirm.
probably a good idea to just
Absolutely.
run that by the parliamentarian. We don't want to kill your bill.
Absolutely.
And so,
Thank you, Mr. Chairman,
Okay.
members. I close.
any other questions, members? Okay,
Thank
thank you
y'all for
very
your
much.
feedback.
And
Thank
so if there's no objection, the chair will leave House Bill 2596 pending.